Hi to all. I am Ron Collins, and together with Floyd Abrams, Nadine Strawson, and Seth Berlin, I'm one of the co-chairs of the First Amendment Salon, and I am delighted to welcome my friend and our special guest, Erwin Chemerinsky, to our program. Before jumping in, I want to start with a few thank yous to make all of this, the people who make all of this possible. First and foremost, the firm of Ballard Spahr for hosting today's program, as they have done for many in the past. So a thank you to Ballard Spahr. Also, the indispensable people who make this possible, Lisa Appel and Lisa Chernowski of Ballard Spahr, and also Whitney Mello of Berkeley for coordinating this program. And a big thank you to all of them. Now, if you have some technical issues, contact Lisa Chernowski or host if you're still connected to WebEx. If for some reason you lose that connection, please reach out to Lisa Appel at APPELL at Ballard, BALLARD, Spahr, SPAHR.com. So let's get going. Special thanks go out to Erwin for joining us today and for sharing his candid thoughts about his experiences on the front lines of campus free speech issues. Although Erwin needs no introduction, I want to just highlight a few items of his long and distinguished career. He's dean and professor at Berkeley Law School, University of California at Berkeley. He's the author of, 19 books and over 200 law review articles on constitutional law, criminal procedure, and federal jurisdiction. Erwin has written extensively on free speech, both generally and on college and university campuses, including his 2017 book, aptly titled Free Speech on Campus. By the way, stay tuned. Erwin's latest book comes out this August and is titled No Democracy Lasts Forever, How the Constitution Threatens the United States. Again, how the Constitution threatens the United States. Boy, we're looking forward to reading that one, Erwin. We are also so grateful to Erwin for serving as a member of our advisory board on the First Amendment Salon. Erwin's time is very pressed, so he's only going to be with us for the first 60 minutes, but immediately following today's exchange, Professor Jeffrey Stone of the University of Chicago will offer some comments, and then we'll go to your questions and what have you. Erwin will be interviewed by my friend and colleague, Seth Berlin, who is a noted First Amendment lawyer and a partner at Ballard Spahr. With that, welcome to all. And now, Seth and Erwin, the online floor is yours. Gentlemen.
Ron, thank you so much. Erwin, it is a great pleasure to engage in today's conversation. Thank you again for being here. Let's just jump right in. Just to set the table, in the past 8 months, we've seen academic institutions under fire. Nothing's been going on. In the few minutes we had to speak beforehand, we were acknowledging how happy everyone was to see the end of the school year. We've seen sustained protests dividing students, faculty, alumni, and donors. We've seen encampments, occupations of buildings, mass arrests, and student suspensions. We've seen at least some speech that tests the mettle of even the staunchest free speech advocates. Students have also sued a number of schools, including Berkeley, and we're going to talk about that today. We've watched as hostile congressional committees have taken leaders to task, and we've seen the Office of Civil Rights open an unprecedented number of investigations based on complaints from all sides of the current campus debate. So really, people in your shoes are getting it from all sides. So let me start with asking this question. In the midst of the current campus speech issues, would you rather lead a public institution or a private college or university? And let me put this just to slightly put one more spin on that question. Would you rather be required as a public institution to follow the First Amendment, which gives you less flexibility, but arguably more cover? Or would you rather have a bit more give in the joints in terms of regulating some speech, but then have to justify the decisions you make?
Let me start by saying what a pleasure it is to be on this program, how much I appreciate the invitation. I want to thank Ron for the incredibly kind introduction. I fear I'm fighting the question. I say, I don't think it should make a difference whether a public or a private university. You're right, of course, that public universities have to follow the First Amendment. Private universities generally don't. But keep in mind, in California, there's a statute, the Leonard Law, that says that private universities cannot punish speech that public universities could not because of the First Amendment. Thus, doesn't really matter in California whether you're a public or a private university. But even if I were a dean or a university president of a private university, I would want to follow the principles of free speech that are embodied in the First Amendment. And so I don't think it should matter in terms of the policies that I adopt, whether I'm constitutionally required by the First Amendment, required by statute like in California, or committed to the same principles of academic freedom and freedom of speech.
And do you think that it's easier than if taking that, and I appreciate your answer. Do you think it's easier at that point to then be a leader of a public institution because you can say to people who question that judgment, we have to, as opposed to we think it's a good idea, or you're comfortable either way?
I'm comfortable either way. And the reality is those who disagree with what I'm doing don't accept the First Amendment as a justification. We had an incident at Berkeley a year ago fall where the Students for Justice in Palestine asked student organizations to adopt a bylaw that they wouldn't invite any speakers who supported the existence of Israel. My position was, under the First Amendment, student groups can choose what speakers to invite or not to invite. And I believe that's a First Amendment requirement. And yet those who disagreed with me weren't persuaded when I said I had to because of the First Amendment.
That's a fair answer, and I want to come back and press on that instance, because it's now, as you I'm sure know, has been the subject of litigation. Before we get there, when a university says our policies provide robust protection for free speech, separate and apart from a First Amendment claim against a public institution, do you think that's enforceable as a matter of contract or quasi-contract?
Yes, though of course a lot depends on how and where it's written. But in general, a faculty handbook or student handbook is construed by the courts to be a contract with the faculty and students respectively. And if they promise academic freedom to faculty, freedom of speech to faculty or students, I do think that's enforceable.
And let me ask a related question. What about a union? If you have a union, is that a policy that the union gets to bargain over?
If it's a public university, the union can't bargain over constitutional rights.
Right.
So to the extent that there are First Amendment rights of faculty and students, they can't be taken away by virtue of a union agreement. In a private university, that's different, of course. If it's not a private university where the law requires complying with free speech, then it could be a subject of bargaining.
And what do you make of the executive order that President Trump issued in 2019 that was later then turned into regulations by the Department of Education, finding that a university or a college could lose its federal funding if it's a public institution, if it doesn't follow the First Amendment, and if it's a private institution, it doesn't follow its own free speech policy. Is that a good thing, or is that actually itself sort of problematic because a university has a policy and then decides for some good and valid reason maybe not to follow it? Is that somehow imposing speech on them?
I think it's problematic on so many levels. To start with, I don't think there's statutory authority for the executive order. Title VI says that recipients of federal funds cannot discriminate on the basis of race. And that's been interpreted by the courts to include ethnicity. If a university violates Title VI, it can lose its federal funding. But the problem with the Trump executive order is it wasn't grounded in any statute. There's also a problem with the Trump executive order in terms of its vagueness. It's so unclear from that executive order what a university might do that would cause it to lose its federal funding. And every major university depends so much on federal dollars. I think that just from a First Amendment perspective, or due process perspective, universities couldn't know what it is that they could or couldn't, or they must or must not do.
But let me just press on that a tiny bit, which is to say, if a university has a policy that says, we adhere to the maximizing speech, and it's done in a way that, as you described it earlier, that it's truly a policy that would be subject to, in whatever way that executive order is interpreted, does the government's requirement that you follow that policy, even if you later decided, in these circumstances, maybe we shouldn't? Is that a speech problem, separate and apart from vagueness?
I would say no, but I also want to recognize why it's complicated. I think the Leonard Law here in California is constitutional in saying to private universities, you have to follow free speech principles. And I think the federal government could adopt such a statute. I question whether it can be done by executive order. There is, though, a complication. To what extent do we want private entities to be able to make their own judgments? What if a private entity says, we want to constitute ourselves in a certain way that excludes certain kinds of speech? We're denying them their ability to do so. And some prominent critics have attacked the Leonard Law on exactly that basis. Julian Ewell wrote a terrific article in the UCLA Law Review when the Leonard Law came out, trying to say that it should be for private entities to decide their own policies with regard to inclusion or speech. I, on the other hand, would defend the Leonard Law or defend imposing free speech obligations on private universities, believing that more speech is a good thing and is what universities should be about.
Fair enough. Let me turn now to talking, if we could, a bit about Title VI. As you alluded, Title VI prohibits discrimination based on race, color, or national origin. Unlike Title VII, for example, it doesn't expressly cover religion, and yet it's been interpreted to apply to shared ancestry and ethnic characteristics, including being Jewish, Muslim, Sikh, Hindu, Christian, and Buddhist, for example. Let me start with this question, which is a little bit outside of the current moment. It's a bit of a hypothetical. Do you think that the current Supreme Court would enforce Title VI in a case based on religion, given that we have a court that is both, or at least a majority of the court, that is both textualist, which might be bothered by the fact that religion isn't mentioned anywhere in the statute, but also is a court that tends to be very solicitous of protecting religion?
It's a great question, and there's no way to know. And there is precedent.
So this is a good question because you can't be wrong.
I like any situation where I can't be wrong. There is precedent here. As you point out, the Supreme Court has been clear that Title VI extends beyond race to shared ancestry and is extended to religion. So the issue is, would the Supreme Court overrule those precedents? On the one hand, precedent has some weight. And on the other, as we've seen, this is not a Supreme Court that gives a lot of weight to precedent. The text of the statute is about race. That's clearly what Congress had in mind in 1964. And yet it's also a court that's very solicitous and protective of religion, as you say. All of which leads me to believe there's just no way to know what the Supreme Court's going to do if the issue comes before it.
So follow up to that, do you think it makes any difference if the discrimination claim at issue is one based on something that really goes to the heart of religious belief, as opposed to the part of being part of those groups that's related to shared ancestry or ethnic characteristics?
I worry that that's a distinction that can't be drawn in practice. Let's take, for example, Judaism. There is obviously a religious component to Judaism. It is a religion, but there's also very much a shared ancestry and cultural aspect to it. You often hear people refer to themselves as, quote, secular Jews. So if there's discrimination against Jews, how are we going to separate whether it's discrimination against them because of the religion or discrimination against them because of the ethnicity of being Jewish? And so that's why I don't know how to answer that question. And I don't think courts are going to want to get to trying to figure out for an individual or a group, is it religion or is it ethnicity?
And where do you think that, just to pick up on your example with Judaism, where do you think that Zionism falls on that axis? Is that a part of being Jewish? Is that separately a political belief that's not a part of it? We've heard students, we've heard lots of people over the last 8 months argue both sides of that.
I've struggled with this question, as I'm sure many people have struggled with this question. Let's start with the definition. Zionism, as I would define it, is a belief that there should be a Jewish state, a Jewish homeland, Israel. Now, one could be Jewish and anti-Zionist against the existence of Israel, and there's some who describe themselves that way. But studies I've seen have shown that about 90% of American Jews would meet this definition of being Zionist, supporting the existence of a Jewish state in Israel. And so then the question becomes, if somebody opposes the existence of Israel, is that anti-Semitic? And it's much debated. Right now, the most prominent position among my students for Justice in Palestine is that Israel should not exist at all. It should be an entirely Palestinian country. That's what they mean when they say from the river to the sea, Palestine be free. That's what they mean when they say, we don't want no two-state, we want 48. Go back to 1948, prior to the existence of Israel. I probably before October 7th would have drawn a distinction between being anti-Zionist and anti-Semitic. But after October 7th, at least in effect, when you oppose the existence of Israel, you're opposing a view that the vast majority of American Jews, and I think worldwide Jews, share.
And I take it that you would think that would be different, for example, if somebody adopted a position that said, I'm just opposed to any state that's related to a religion. I don't think there should be a Vatican. I don't think there should be a Church of England. But that when it's sort of Israel by itself, that's sort of the basis for that contention.
That's exactly right.
So I want to come back to some of what you said in a little bit, but let me ask you a couple of other questions just about the mechanics of Title VI. Right? To have a hostile environment claim under Title VI, you need conduct that's subjectively and objectively offensive, so severe and or pervasive. And this is the thing I want to ask you about, which is the and the or, and that limits or denies a person's ability to participate or benefit from a student's educational program or activity, right? So you've those different elements. Office of Civil Rights of the Department of Education tells it's is severe or pervasive. Right. And they've reiterated that position in the agreements that it reached with University of Michigan and CUNY in the last couple of weeks and with Lafayette on Friday. Right. Judicial decisions pretty uniformly when they resolve claims by private litigants tell us we need conduct that's both severe and pervasive. It's a more demanding standard. Who has that right? Or is this one of those cases that an agency gets more leeway to enforce something than a private litigant?
And of course, whether agencies get deference is an issue that's now pending before the Supreme Court.
I should ask you this next week, and you can tell me whether.
Right, this is the so-called issue of Chevron deference. Should there be deference to the Department of Education in interpreting the statute operates under Title VI? My own sense is that severe or pervasive is the better approach here. And the reason is, imagine a single incident that is so targeted that it clearly is harassment. A dormitory where somebody paints a swastika on the door of a room that's occupied by a Jewish individual. Or imagine that there's a dormitory room occupied by a Black student and somebody tacks a noose onto that door. That's severe enough to constitute harassment. But it can also be pervasive. And the key is in the language that you read earlier, that it has to materially interfere with educational opportunities on the basis of race or religion or sex or sexual orientation. And I think it is either severe or pervasive. It can meet the standards under Title VI. Keep in mind that this isn't the language of the statute. This is the language that comes from interpreting the statute. And then the question is, will the court defer to the Department of Education, or will the Supreme Court go its own way?
But you would go with severe or pervasive.
I would. Because I believe a single incident can be targeted and so interfere with educational opportunities. It shouldn't need to be pervasive even in the workplace or repeated as against a particular individual.
And relatedly, the Office of Civil Rights also has told us that speech or conduct can amount to harassment, even if the statements are not directed to a particular individual. Do you think that's kosher?
Yes, and this is what the courts have said for some time. Imagine a workplace where there's pervasive presence of white supremacist images. Imagine, say, that workplace has such pervasive material of that sort is to create a hostile environment for a Black employee. Or imagine a workplace where there's pinups or posters that are extremely offensive and sexually explicit. One could find, and some courts have found, that that creates a hostile environment for women employees, even if it's not targeted to a particular woman, or in my prior example, a particular African-American individual.
And if that's the case, right, it seems to me that for those of us who are, free speech people, we've watched a lot of the speech that has happened on college campuses and looked at it and said, well, that seems like that's a permissible, even if it's offensive, right? We have in this country a long and distinguished history of protecting even hate speech, which it's not necessarily shared by other countries. But is there some point at which, in the aggregate, and here I'm going to pervasive, right? A student says, I have to go to class every day past an encampment where people are shouting at me hateful things, or shouting hateful things even if not at me. Is there some point at which that becomes pervasive enough, and again, to make the point you made a minute ago, that it actually limits my ability to take advantage of my education?
Yes, I think that there is a point at which the speech is so pervasive is it interferes with educational opportunities. In fact, the Department of Education, in a Dear Colleague letter by the Assistant Secretary Catherine Lehman, has been clear that even speech that's protected by the First Amendment can be so pervasive as to amount to harassment. But then the question is, what's the obligation of the university? People too quickly assume that the obligation of the university is to stop or punish the harassing speech. That's not necessarily so. There are many other things that a college or university can do if the speech rises to the level of harassment without punishing the speech. I was involved and argued a case in the United States Court of Appeals for the Fourth Circuit several years ago. It was a case called Feminist Majority Foundation versus Hurley.
Hurley, yeah.
Mary Washington University. And there was a debate on campus as to whether to allow Greek life. 3 women wrote an op-ed in the campus newspaper opposing Greek life, saying that when there's fraternities on campus, there's more violence against women. They were then targeted with over 600 vile messages over the social media platform Yik Yak. And so here you do have targeted speech. They went to the campus administrators and they said, we can't do anything about this. It's anonymous speech over social media. The campus even put on its website, we're not responsible for anonymous speech over social media. The women sued. The district court dismissed the case on First Amendment grounds. I represented the women in the Fourth Circuit, and the Fourth Circuit ruled in their favor. And what the court made clear was that once there was harassment, and here it's under Title IX about sex rather than Title VI about race, that means the campus can't be deliberately indifferent. And that's the standard in both Title VI and Title IX. There can't be deliberate indifference. And there are many things that a campus can do to avoid deliberate indifference. In fact, to go back to Catherine Lehman's Dear Colleague letter from a couple of months ago, she talked about how campus officials can condemn the harassing speech, how campus officials can provide protection for students, how there can be training programs, and this whole list of things. So what I want to emphasize is when there's harassment under Title VI, the campus has a duty. The duty is to not be deliberately indifferent, but that doesn't necessarily mean, because the First Amendment for a public university perhaps cannot mean punishing or stopping the speech.
In that instance, right, one of the examples you gave was the university could issue statements condemning the speech. And I guess one question I have is we've seen a lot of back and forth debate among university leaders about whether issuing statements is a good idea or not a good idea, and both sort of as a general philosophical matter, but also as a speech matter. There's some who said, well, that's an exercise of the university leadership's free speech, right? And it doesn't, those people who you become a president or a dean, you don't give up your speech rights. And others have said, that's not the job. The job is to maintain a neutral platform on speech. Do you have a view about, where do you come out on all that?
I do. I think there are times when campus officials must speak out. And for me, what I follow is the criterion: when would my silence be a message in the wrong message? So after the tragic death of George Floyd in late May of 2020, I felt to not speak out would have been the wrong message. I thought that my community wanted me to be able to voice the pain that some were feeling, to express compassion. I felt after January 6th to not speak out as a dean of a law school committed to the rule of law would have been the wrong message. Or to come to what you're speaking about, several years ago, Alan Dershowitz, the Harvard law professor, was speaking at Berkeley Law, and there were posters advertising the event throughout the school. Someone drew a swastika on one of the posters of Alan Dershowitz. I, as soon as I saw it, immediately sent a message to the campus and to the law school community condemning that, to say that it was inconsistent with our principles of community and what we stand for as an institution. My silence in the face of that would be the wrong message. That said, I am reticent to send messages to the community. I think that I should do so only in very limited circumstances that relate to the law school and who's here. And also, I recognize more pragmatically, the more messages I send, the fewer that will be read. And I want to make sure my message is going to be constructive and not divisive, but I also want to make sure the situation where if I were silent, that would be the wrong message.
So in that answer, you sort of you alluded to both something happening directly on your campus, the Alan Dershowitz example, as well as things that had somewhat more attenuated relationship directly to the campus, the belief in the rule of law or belief in equality under the law with the murder of George Floyd, and so I take it that you have a broader view of this than, let's say, the policy that Harvard just has now is adopted, which is unless it relates directly to our campus, we're not going to say anything.
I'm broader than that. I mean, I believe that the death of George Floyd affected people in my law school, and so in that sense, I could, if I take the Harvard approach broadly, fit within it. Or I thought that being a law school, the insurrection on January 6th was about the rule of law, so to speak out. I'm probably closer to the Harvard policy than the so-called Calvin principles, where the administrators don't speak out at all. But for me, it really is a judgment of, well, I help my institution by saying something, or do I think I'll hurt my institution? I didn't say anything when Roe versus Wade got overruled. I didn't say anything when the affirmative action case got overruled. I didn't feel the need to speak to the community in that way. But let me also say what I'm talking about here is a message that I send to all of the students, staff, faculty in the law school. That's different from when I write an op-ed piece, because I do write op-ed pieces on all of those subjects, and they express my views, hopefully perceive it as my speaking as an individual, albeit it still says I'm dean of a law school, but I take that as something quite different than the message I send to the community.
You wrote a piece, speaking of that, you wrote a piece last, I guess it was in late October, in the LA Times, noting that in your time as a academic that you had not seen as much anti-Semitism as you were seeing then and maybe since. What was the reaction to that piece, both on your campus and around the country?
I thought a great deal before I wrote that piece, because even though it's published in the Los Angeles Times, it's obviously read by those within my law school. At that moment in time, I had not seen the condemnation of the anti-Semitism that had been expressed after October 7th. And I had seen it personally and certainly had read it online and in the videos that I watched. To answer your question directly, I've written probably thousands of op-eds over the years. I've never written an op-ed that generated so much reaction. On the one hand, I've never written an op-ed that got so much positive reaction from people, not just across the country, but across the world. I've also not written an op-ed that generated as much hate mail and death threats as that did. And within my community, it was a very divided reaction. There were those who applauded it, and there were those who were very angry at me for writing it.
How so? I mean, what are they angry about? That you're, I mean, it seems like that's part of, you're somebody who values speech. You ought to be able to speak. But they're angry about the particulars of the viewpoint that you expressed.
Yeah, they felt that I was saying that some of what my students had expressed was anti-Semitic. To be clear, I wasn't calling anyone anti-Semitic. I was saying that some of what was said, and I can relate those incidents now, were perceived by me to be anti-Semitic. And I felt that some of what was said across campuses after October 7th was anti-Semitic. And the point of the op-ed was to call on campus officials to condemn anti-Semitism and the expression of anti-Semitism is the same way they would criticize and condemn racism and the expression of racism.
You mentioned earlier the slogan "From the River to the Sea," and that you think that there are a large number of people who mean by that a single Palestinian state, and by extension, the elimination of the Israel that's there. Is that something that you take to be anti-Semitic?
I am sure that people can mean many different things with the phrase "from the river to the sea, Palestine should be free." On the other hand, I felt that after October 7th, those who called for the elimination of Israel were expressing what I would regard as anti-Semitism.
Let me ask you about the definition of anti-Semitism, right? There's been a lot of conversation on college campuses about how to define it. There's, I guess, legislation pending now mandating that the Office of Civil Rights use the definition that was put forward by the International Holocaust Remembrance Alliance, the IRA definition. And it's a definition that at least in part has been recognized in some way by both the Trump and Biden administrations. And I'm interested in your view about whether that's a useful definition or if that's a problematic definition, or maybe both.
I think there are parts of it that are useful, but there are parts of it that are problematic. Let me give you an example of the latter. One of the things it says is calling on Israel to meet a higher standard is regarded under that definition as anti-Semitic. I very much disagree with that. I call on the United States to meet the highest possible standard with regard to morality. I don't believe that makes me anti-American. I expect Israel to meet the highest standards of morality. I don't think that makes me anti-Semitic.
And so is the right approach, I take it you're not in favor of this legislation that says this is the mandatory definition, but the approach, for example, of the current Office of Civil Rights has been, this is something we'll consider, but not necessarily something that we will apply as the sole yardstick for measuring conduct and speech. That's about where you fall out?
Yes.
Let me ask you, if I could, I want to turn back. We talked about this a little earlier in the conversation, to this lawsuit about the bylaws. And it's not only about the bylaws, but I sort of want to focus on that if we could. That's brought by the Brandeis folks. Can you, just for the benefit of the people on the call, say just a word about the allegations in the case? And then I have some questions for you about it.
Sure. Again, to go back, in the fall of 2022, the Law Students for Justice in Palestine and the law school urged other student organizations to adopt a bylaw that they wouldn't invite any speakers who supported, in a quote, Zionism, comma, the apartheid state of Israel, comma, or the Palestinian occupation, and to require the members of those organizations to participate in a training, a Palestine 101 training put on by the Law Students for Justice in Palestine. About a dozen student organizations out of over 100 adopted the bylaw. Immediately on learning of the bylaw, I sent a message to the leaders of all student groups in the law school saying that we should be a place where all ideas and views can be expressed. I believe the bylaw is inconsistent with our values. I would not be allowed to speak at an organization that adopts the bylaw, but I believe that student groups have a First Amendment right to choose the speakers they want based on viewpoint. The college Republicans can decide this year to invite only conservatives. The Women's Law Association can adopt a bylaw that only adopt pro-choice speakers. I should also point out that this past fall, some of our law journals began to adopt a bylaw that they would not publish any authors who supported Zionism, the apartheid state of Israel, or the Palestinian occupation. And the difference is that the law journals receive, or the members of it, receive academic credit. And the law journals are published by the regents of the University of California, an authority delegated to the law school. So my position is we wouldn't give academic credit to journals that adopted the bylaw. We wouldn't allow a civil procedure teacher or corporations teacher to require the students undergo a Palestine 101 training, nor could the law journal as a condition for credit require that. And the regents of the University of California, an authority delegated to the law school, wouldn't publish journals that did this. Not surprisingly, I've been criticized by both sides. There are those who think we should outlaw the bylaw with regard to speakers, and those who are angry at me with regard to the position concerning journals. And yet I believe that what I'm doing is consistent with, even required by the First Amendment.
Let me ask you a couple, I got more than a couple questions about that. What in the groups that adopted it, as I understand the case, were a journal and a clinic, right? Two things that you sort of think of as consummate parts of legal education. And if that's going on, right? And let's imagine that this goes not for a dozen of 100 student groups, but let's assume that that it catches on like wildfire and that more groups do it. At some point, do the students who are complaining have some argument, at least a plausible argument, that this is depriving them of the limit? It's denying or limiting, I guess is probably the better term, limiting, as the statute or the interpretation of the statute would say, their education.
First, the law school has an all-comers policy where all student groups have to be open to all students, and all activities of student groups have to be open to all students. I have heard of no instance in which that has been violated. Second, to my knowledge, no student group has ever refused to invite somebody on account of not complying with the bylaw. It's thus far been symbolic. So then you say to me, might there be a point at which the bylaws, taken cumulatively, have a discriminatory impact? And what I say is, to this point, there's absolutely no indication of that. And what we have to keep in mind is, I do believe that a student group in choosing speakers can do so on the basis of viewpoint, but that to me is very different than a law journal. As to your two examples, the law journal that adopted it, the Women's Law Journal, has since changed its bylaw in light of the policy that adopted. And it wasn't a clinic, it was a pro bono project, and it too no longer has such a bylaw. So I would draw a very important distinction between student groups inviting speakers as opposed to anything that's curricular, or it's credit, or that's administered by the law school, and their bylaws are no longer allowed.
If the argument is, and I'm going to play devil's advocate here for a little if I could, if the argument is that we have a bylaw that says no Zionist speakers, right? And as you said earlier, some portion of like 90% of American Jews think of themselves as having some belief in Zionism. Is that essentially pretextually a claim that says, Jews are not welcome here? And is there some plausible argument that that is the case? And let me add to my question, if I could. I take the point, and you were quoted saying this in response to when this first came out, that Hillel has policies that say we don't invite speakers that seek to delegitimize the state of Israel, right? Sort of the mirror image, if you will. And it seems to me non-controversial to say that students for justice in Palestine shouldn't be required to invite Zionist speakers, just like Hillel shouldn't be required to invite speakers that seek to delegitimize Israel. But when it expands perhaps to other groups that are not, where their mission isn't really about Mideast politics and is about something else, then is at least plausible to say, well, maybe that makes me wonder whether this is a pretext for no Jews, need apply, or Jews not welcome. And I think, to me, that is one of perhaps the two harder parts of the case, and I'm interested in your views about it.
I think you raise a very difficult question. I don't think it's one that's posed by this situation, because in this situation, there's no indication that anybody's been excluded. Keep in mind that for Title VI, what there has to be is there not be deliberate indifference. And I think if you look at all the things the law school and the campus have done, there hasn't been deliberate indifference. The lawsuit alleges that there is a violation, discrimination on the basis of contract, 42 United States Constitution 1981.
Yeah.
Nobody has been discriminated against on the basis of contract. So I think in this lawsuit, that's not the issue. But I think you raise a very difficult question. What's hard for me, though, is what if the Catholic law students say, we're only going to invite speakers who support a ban on abortion? Doesn't that have an effect of excluding certain people? Or imagine the Women's Law Association says, we're only going to invite pro-choice speakers. And the Catholic students come forward and say, but we feel excluded by that. So I think it is very difficult to say, what is the point that choice as to speakers in itself becomes discriminatory under Title VI, Title IX? And then what does deliberate indifference mean in that situation? Because that's the standard. The campus can't be deliberately indifferent.
Seems to me that one of the things that's fascinating about this bylaw is that the goal, and I think this was one of the people who adopted it was quoted, I'm paraphrasing, so this isn't a quotation, but saying something along the lines of, our goal is to make Zionists very uncomfortable on this campus, right? And it seems to me that, and I think this is consistent with what you said to the campus, it's an odd position to say, for you to say as a free speech, protector of free speech, this is something that we need to do because it protects speech, when the underlying goal is essentially, in some respects, speech suppressive of a particular viewpoint. And to me, that seems to me, I mean, in cases like Hurley, not your Hurley case, the Supreme Court Hurley case about the parade, this is the problem that the court's grappling with, which is, your associational right of a group versus the individual, speech and thought rights that come clashing into each other.
In Hurley was a 9-0 decision of the Supreme Court. It involved a group that put on a parade in Boston for St. Patrick's Day, and they excluded a gay, lesbian pride group from being able to march in their parade. And the Supreme Court said 9-0 that those who are organizing an expressive activity like a parade get to determine the message for that parade, even though it meant discriminating against gay and lesbian individuals. And it was especially based on Hurley that I felt that, as much as I detest the bylaw, student groups can choose speakers on the basis of viewpoint. And remember, the obligation of the university is we can't be deliberately indifferent. And so I think all of the things that we did, including condemning the bylaw and expressing why it was inconsistent with our values, show that we weren't violating Title VI.
Yeah. And on that last question, I was sort of less focused on whether it was a Title VI violation than just, these clashing free speech values, because it seems to me, especially
Yes.
with our First Amendment salon, it seems to me that that's a difficult thing. And let me just expand the focus a little bit. So if I understand our conversation so far, you basically, I think, have said that you would be in favor, you sort of like the Leonard Law and think that colleges and universities should not be permitted to sort of ban certain groups or certain speech, certain groups that espouse certain speech, but that groups themselves should be allowed to do that. And I guess one question I have is, what's the difference?
Well, I think there's an enormous difference between the institution as institution and a student group within the institution. The institution as institution has all sorts of obligations that don't extend to groups within. Now, that doesn't mean that the student groups are unlimited. We all agree they can't discriminate on the basis of race or sex or religion or sexual orientation. But the student groups certainly get to exercise their free speech rights in a way that I don't attribute free speech to institutions in the same manner.
So, for example, there was a case a few years ago involving Fordham, which declined to recognize Students for Justice in Palestine as a official campus group and said it's inconsistent with our views, including as a Catholic university. And that went up to the First Department, and that decision was affirmed. And I take it that your view is that that's problematic for a university.
I want to separate what the law is in a jurisdiction from a discussion of what should be the law in a jurisdiction.
Yeah.
In New York, there is not the equivalent of a Leonard Law. Remember, the Leonard Law is in California. It says that a private university can't punish speech that a public university couldn't punish because of the First Amendment. I think in the context of a private university in California, it'd be a much more difficult question. Now, what Fordham adds to it is the free exercise of religion dimension. And to what extent does a religious school have the ability to constitute itself in a certain way that a secular university wouldn't? And if you give religious universities that, but you don't give it to secular universities, do you then create an establishment clause problem under the First Amendment? So there's so many layers of analysis, but the Fordham case becomes easier because Fordham is a private university in a state that doesn't have something like the Leonard Law.
Yeah, and I was asking more the normative question, which is, do you think that that's a good thing or a not good thing? I understand that obviously New York has less protection for speech on private college campuses.
Having thought about this a lot, I've come to the conclusion that I'd like to see all universities follow free speech principles. I recognize that I'm denying them a certain self-determination, but I believe it's the nature of what a university should be about, is that it should have a commitment to academic freedom and be a place where all ideas and views can be expressed.
Let me ask you a couple of questions about protests, which is to say, we have, there's been a lot of examples of sometimes press, sometimes advocacy groups identifying and publicizing the identities of protesters, right? In some instances, there's been a question as, can and should protesters be allowed to wear masks, putting aside being tied up with, health reasons, just for purposes of not being able to be identified. Do you have thoughts about whether that's, rules that are against, quote unquote, doxing or a good thing, bad thing? Because then again, here's a place where, on the one hand, the college newspaper publishes a story and identifies people who are at a protest. It seems like a reasonable exercise of free speech rights. On the other hand, the advocate who's trying to get people to stop advocating by putting their name on a billboard and running it around the campus, it seems speech suppressive. And I'm interested in sort of how you think about that tension.
First, I think that which we do in public is there for the world to observe. And if someone then publicizes what we've done in public, I don't think we can claim it's an infringement of our rights, that it's a public disclosure of private facts. Second, I've shifted my views with regard to masks. On the one hand, there is a First Amendment right to speak anonymously, and wearing masks facilitates being able to speak anonymously. On the other hand, what we've seen on campuses over the last several months is it becomes impossible to enforce not just campus rules, but the law when people are wearing masks. And so a number of cases were dismissed last week involving Columbia protesters, in part because they were wearing masks and there's no way to know who they are. We had a horrible incident on the Berkeley campus where there was demonstrators that prevented a speaker from being able to be there, but the demonstrators were wearing masks. There are some lower court cases that have upheld anti-masking laws that were based on trying to stop the Klan. And I've come to the conclusion that anti-masking laws at protests would be constitutional, but it's not something the Supreme Court's ever addressed. It's not something that's ever been resolved.
What about at the protest, if you have, well, I'm mindful of the time. Let me actually ask a different question. I want to come to perhaps the most delicate set of questions, which is about events that took place literally in your backyard. When we said you were on the front lines of these battles, it doesn't get any more front line-ish than being in your backyard. I have a couple questions, but I guess I think I would start by just offering you the floor to see if you have any comments that you'd like to make about those events.
Sure. I fear that most people who are watching and listening know what I'm talking about. Just to put it in context, as long as I've been a dean, which is 16 years now, I've always done a dinner at the beginning of the school year for the incoming students. We do it over many nights, and the students are each assigned or can pick a night. The class that graduated on May 10th of this year didn't have dinners when they were first-year students. They began in 2021. Because of COVID, we couldn't do dinners at that time. So the presidents of the third-year class asked if my wife and I would hold dinners for them before commencement. And we picked 3 nights in April 9th, 10th, and 11th for those dinners. And any graduating student could come to any one of those dinners. The week before, on Monday, April 1st, posters went up on every bulletin board in the law school and online. It had a caricature of me holding a bloody knife and fork with blood around my lips and said to boycott Zionist Chem's dinners. The posters didn't object to anything I have said or done. They called for the University of California to divest from Israel, and the law school has no influence over that. The first dinner was on Tuesday, April 9th. My wife and I greeted the students as they arrived in front of our house. I was surprised to see the leaders of the law students just in Palestine come. And my initial thought was, I hope they're not here to disrupt. And then I thought, no, isn't it wonderful that they've decided to set aside their protest and come? Everyone went to the backyard. There was about a half hour sitting around and having drinks. And then everyone went through the buffet line and got food. Once everyone was sitting down, the leader of the law students just Palestine was responsible for the poster, took a microphone out of her backyard and went up on the steps and began to talk about the plight of the Palestinians. I immediately got up and said, stop, please leave. In all of the dinners we've done, there's never been a speaker of any kind. The student continued. My wife asked her to leave. My wife grabbed the microphone. A scuffle ensued. The student said, if you let go of the microphone, we'll leave. My wife let go of the microphone. 10 students walked out. This was all recorded. It went viral amazingly fast and then was written up in every newspaper you can think of.
And so now that, that's a little more than 2 months ago, do you have any sort of, what is your thinking now looking back on all of that? As a dean, as somebody who's, been very committed to free speech, as somebody who's obviously felt that the space of their home was perhaps made a platform in a way that you didn't want.
First, it wasn't a free speech issue at all. Even if this event had been held in the law school, there's no First Amendment right to come and disrupt it. Justice Sotomayor came to Berkeley Law in January. We had a lunch for the faculty. If a student had stood up and disrupted it, that wouldn't be protected by the First Amendment. She did a talk to the students. If the student had disrupted it, wouldn't be protected by the First Amendment. And it doesn't get more protection of the First Amendment because it's at our home. In fact, our home is private property. It's not owned by the University of California. And under California law, when someone is asked to leave a home, they're a trespasser. I wish very much that this had never happened. It's been an enormously painful experience for my wife and me. It's hard to describe what it's like when something goes viral and it's about you, the hate messages, the death threats we received. So in hindsight, I wish we hadn't done the dinners at all. We were afraid it might be disrupted. And so we brought someone if there had been a disruption so that my wife and I wouldn't get involved. But we thought if there's a disruption, it would be in the front of the house. And that person was sitting in the front of the house, not in the backyard. And you can't hear in the front of the house what's going on in the backyard.
Wow. So we are basically at time. I guess I'll give you the floor. We have just another couple of minutes at the most. I know you have to go on to the next thing. Is there anything that we talked about or didn't talk about that you think, as you think about it, for an audience of people interested in free speech, and we have a number of people who are also probably interested in academia, that you would like to share?
Sure. One thought that we touched on but didn't get into, I've come to realize in the last couple of months how much some of the hard issues is what's been facing campus aren't questions of First Amendment or free speech, but a question about what's pragmatic and politically desirable to do. Let me focus on the encampments on many campuses or the disruption of graduation. There's no doubt that the encampments have violated constitutionally permissible time, place, and manner restrictions. Campuses constitutionally could have the encampments removed. When students or protesters have disrupted commencement, they don't have the First Amendment right to do that. The campus constitutionally have removed. I've always tended to look at free speech issues through the lens of the First Amendment, but I've come to realize these aren't First Amendment questions at all. They're questions about what's pragmatically desirable, what's politically desirable to do. And I think we need to focus on what are the criteria for evaluating that. Let me tell you what I mean. One question is, how much is the encampment disrupting the educational research mission of the campus? Sometimes they have, sometimes they've been less disruptive. How much is the harassment attendant to the encampment? What's the risk of violence from allowing the encampment to be there? What's been past practice? What precedent is being set for the future? Because if you allow the encampment for this, you've got to allow encampments for other things. What are the consequences of enforcement? If the police come, what's the consequence? If the campus uses disciplinary proceedings, what's the consequences? Notice that all of these are not First Amendment considerations. They're much more what's pragmatic and politically desirable. And I hadn't thought about it that way until the last couple of months. And I think it's important we do think about it that way as we go forward, because the reality is, I think the fall isn't going to be much different than the spring in terms of the protests we're going to see.
I sadly feel like you're right about that. Let me ask one follow-up about that. Some campuses were, and I realize campuses are not monolithic across the country, so that's an important caveat, but some campuses were calling the police on students and having them escorted off with the police, and other campuses were engaging in disciplinary processes where they were suspending students. Do you have any views about which one of those things is more pragmatic, to use your word?
It depends on the context and circumstances. So one question that I didn't mention, is it a violation of the law or is it a violation of a campus rule? When the demonstrations become occupation of buildings and they include vandalism and destroying property, I think there's no choice at that stage but to call the police. On the other hand, when it's an encampment in a corner of the campus that's not disrupting the campus, then I don't think it makes sense to call the police. So to use your phrase, I don't think it's monolithic in terms of situations either.
This has been really, really great. Thank you so much for giving us your time, your wisdom. We really appreciate it a great deal. I know you have to run to the next thing. You're welcome to stay as long as you can. But
I'd love to, because I'd love to hear Jeff Stone. There's no one who I admire more in academia, no one I admire more to go to the First Amendment. But unfortunately, I actually do have a meeting that I have to go to. So thank you so much for having me, and I hope we get to do this again. Your questions were wonderful and so thought-provoking.
And Erwin, just before you go, a big thank you. We are so in need of informed views in these uninformed times, and your views really help move that along. So thank you, and we wish you well.
Oh, thank you for having me, and I hope we can do it again sometime soon. Thank you.
Thanks again.
Well, with that, we turn to another friend and somebody else who's on our advisory board, Jeffrey Stone, the Edward Levy Distinguished Service Professor at the University of Chicago. Jeffrey, are you with us? We're just waiting for Jeff to come on.
Yeah, I just unmuted. Can you hear me here?
Yes, we're still waiting to see you, though.
Okay, there we go.
Oh, there you are. There you are.
I didn't know I had to do all that.
Okay, well, let me start again. First of all, Jeffrey, another good friend and somebody who is on our advisory board, and we're so delighted to have the Edward Levy Distinguished Service Professor at the University of Chicago. And a special shout out to you. I mean, not for all of the works you've done on constitutional law, but unless I'm mistaken, this year is the 20th anniversary of that seminal book, Perilous Times, Free Speech in Wartime. I think it was 2004 that it was published. And if that's true,
I think that's right. Yeah.
We're 20 years. So congratulations.
Thank you.
If you don't know about Stone and free speech, this is just one of several books that Jeff has done, and we're so delighted to have you, Jeff. Erwin mentioned the Calvin principles in the course of his remarks. Might we just kind of pivot from there, and how do such principles, in terms of your views on what Erwin says, how do they inform your views?
So if I understood Erwin correctly, I think he was not fully endorsing the Calvin principles, and was taking the view that there are circumstances in which it is appropriate for a university to take positions on certain issues when he thinks they are especially controversial or problematic. The Calvin report was the result of a committee chaired by Harry Calvin, who was my First Amendment professor when I was a student at the University of Chicago. And it basically addressed the question of, when should a university take positions on public issues? And it essentially said that it should not do that. That unless it is dealing with a matter that directly affects the functioning of the university, like, for example, affirmative action, or tax rules that directly affect the university, then except for circumstances like that, the university should simply be neutral and should not have a voice with respect to matters like what's going on in Israel and Palestine, for example. And the basic view there of the Calvin report is that the fundamental mission of the university is to have a culture in which faculty and students feel comfortable saying whatever they think, whatever they believe should be said, and to make the arguments that they wish to make. And that if the university takes positions about what it believes to be right and wrong, that will clearly have a chilling effect on the willingness of faculty and students to take their own positions. Moreover, if it does that, it invites trustees and donors to basically say, take this position. I think this is important. You should basically take position X, Y, or Z, because if you want me to keep giving you money, you've got to do that. So the basic point of the Calvin Commission and report was to essentially say that universities should be neutral as institutions. And that doesn't mean faculty members can't say or write whatever they wish, of course, but it does mean that the institutions should be neutral. And I think that has stood the University of Chicago in very good stead over the years. And I think it's fundamentally correct if one wants to have a university that fully supports and invites open debate and discourse and disagreement among the core academic components of the institution, that is the faculty and the students.
Before we turn to questions and comments from the audience, do you have any other views or comments about what Erwin said?
Well, I mean, first of all, I want to emphasize that I agree with Erwin's early comment that private universities, I think, as a general matter, should embrace the essence of current First Amendment jurisprudence. That would not have been true 60 years ago when First Amendment jurisprudence sucked. But I think we've reached a point now, even though we don't agree with all of it, obviously, in which it sets forth a very sound set of principles that universities should be governed by. That is, you do not suppress speech because the message is thought to be offensive or hurtful or problematic. You can have content neutral regulations that are designed not to suppress particular ideas, but are designed to enable the university to function properly. And also that you can restrict the speech of employees, like faculty members, at least in certain circumstances. So in the classroom, if a chemistry professor wants to spend his time talking about abortion, that's not appropriate. And those are all principles that I think one derives very much from the Supreme Court's First Amendment jurisprudence. And I think those are the right principles for which universities should run. Now, that doesn't mean I agree with all of First Amendment jurisprudence. Take, for example, campaign finance law and Citizens United. I think that's a pretty terrible decision. And so that's not as if I'm endorsing all of First Amendment jurisprudence, but I think the core principles that the court has come up with over the last 60 years or so make a great deal of sense for the nation and also make a great deal of sense for universities. And that's why the University of Chicago Principles, which was a committee in 2014 that I chaired, essentially adopt the First Amendment principles as what we regard as the appropriate way for our university to deal with these sorts of questions.
Seth, would you care to weigh in and ask Jeff any questions or comment?
Let me ask if I could a specific example. We saw at the perhaps most well publicized hearing of about these topics in front of the House committee, presidents of 3 respected universities get asked, would a call for genocide constitute a violation of your policies? And they, I think appropriately, although perhaps not appropriately in a political sense, but appropriately in a legal sense, said, well, it depends on the context. In the days that followed, both those institutions and a number of other institutions said an explicit call for genocide. And remember, that question was set up as a precursor to the question about, how do you interpret a phrase like from the river to the sea, Palestine should be free. In that instance, a number of universities came forward and said, we think that this is actually a violation of our policies. The New York governor came forward and said, we think that's a violation of New York law if you don't police that. And when I asked Erwin initially about whether he prefers public institution or private institution, and again, he was right to point out that that's not meaningful in California, but in other places, that's an example that came to mind, because there are places where a university might say, well, we generally are protective of free speech, but what's essentially an implicit, desire to get rid of a whole segment of our campus might be a bridge too far. On the one hand, if you really adhere to First Amendment principles, maybe you have to tolerate that. On the other hand, maybe there are some things that for the good of the order are, maybe just not allowed. And I wonder, is there any sort of sphere where that's the case?
My own view is that the First Amendment has this right. That is, individuals who express views that are offensive, problematic, might lead to, at some point, violence, are protected by the First Amendment. And I think that's correct in a democracy, and I think it's correct in an academic institution. It doesn't mean that faculty members can't criticize that. It doesn't mean that other students can't criticize that. But I don't think universities should be in the business of censoring that type of speech, because again, what I worry about is once you open the door to censorship, it's hard to close it. And what other people would say, well, you can't advocate abortion because that's just like genocide. And so universities should prohibit anyone who advocates abortion from doing so. And you can go down that road in all sorts of different directions. And so, my view is that what the Supreme Court has ultimately come up with respect to viewpoint discrimination and prohibition is right. It doesn't mean that all views are good. It doesn't mean they're not harmful. It means that we don't want people in positions of power to have the authority to decide what can be said and what can't be said. And again, it's not just a matter of trusting provosts and presidents. It's also about trustees and donors. And if you're used to being involved in running the university, you can see the danger that's involved in that.
And when you said in that instance, you said, but it would be okay for faculty members or other students to criticize the expression of that viewpoint. I take it from what you said in response to Ron's question that you would perhaps draw the line at, let's say, the president of the university saying that, that call for genocide is not consistent with our values here at University of Chicago?
I think a president of the university can, if they're careful about it, speak in their own voice as an individual. But I don't think they should say this is inconsistent with our values as a university. I think the president could say, I think that's terrible. I think an individual shouldn't say this type of thing. I think it's immoral, it's hurtful, and it's unwise. But I'm speaking only for myself in my private capacity, not as a voice of the university. I think it's tricky, but I think that's a distinction that one can make, and often presidents and deans and provosts do that.
Yeah, well, Erwin gave a number of examples in his comments.
Right.
But so it would be okay for a dean, it would be okay for a faculty member to say, I think that was terrible that you said that, and that's inconsistent with the values of our university, as long as it's clear they're speaking in their own voice.
Absolutely.
But and again, the same would be true of the president, but the president speaks for the president, right? Because
it's trickier when the president or dean speaks in their own voice, because people will often attribute that to the institution. So it has to be very explicit about the fact that you're speaking in your own voice. But I do think that a dean or a provost or a president can speak in their own voice, as long as they make clear that's what they're doing.
So we invite folks to ask questions. And Jeff, since we have you here, we're going to, if you're okay with it, ask you perhaps to address some of the questions that are coming forward. Of course, we open it to everyone. And so you'll be speaking for yourself and Erwin, as it were. So we have a question from Wendy Tarlow, and here's the question. Do you believe the way schools are handling these
Ron,
issues?
that's actually from somebody, that's from Jerry, and I'm not sure.
Oh, I see. I thought it says here, Wendy.
Just above that, it's Wendy's name, but.
Oh, okay. Well, we have a question then. Let me just put it this way. Oh, sorry. It's from, I sit corrected. It's from Jerry, and Jerry, my apologies. And also to Wendy as well. So the question from Jerry is, do you believe the way schools are handling these issues regarding protests against Israel is consistent with the way schools have handled free speech issues in other contexts over the past few years regarding other controversial issues? So in other words, is there some kind of difference in treatment here? What do you think?
I think that the primary difference is not just the message that's being communicated, it's the means that they're being communicated. That is one of the things we're seeing in the current situation, which we've seen in the anti-Vietnam War protests and civil rights protests, is that it's not just a matter of taking and expressing positions. It's a matter of doing it in a way that is intentionally controversial and violative of the ordinary rules of the institution, because that's how you get attention. And I think that part of what distinguishes this from those other circumstances is that they are so controversial, in part because it's not just about the ideas they're expressing, it's about the way they are doing it that violates the content neutral rules that universities otherwise have. And so I think that's sort of unique in the current moment with respect to the kind of views that are being expressed. My sense is if individuals were expressing these views in the same way that they're handing out leaflets, for example, or giving talks to a student organization, we wouldn't be having this conversation today. The fact is that these students and their supporters understood that the way to get the New York Times and the Washington Post to cover these stories is by doing things that are highly provocative and go well beyond just ideas and expression of opinions, but violating the rules and norms of an institution, which puts the institutions in a very difficult position because they don't want to suppress the speech, but they also want to make sure that the speech is not being carried out in a way that is undermining the basic functioning of the institution.
And are we still waiting, I think, for any other comments or questions? I don't see.
We can give it a minute if anybody else wants to weigh in.
While we're waiting, Jeff, you are not only a free speech advocate, but you're also a professor. You're a professor at a university, and you're a professor at the University of Chicago. If my memory serves me correctly, in 1987, there was a University of Chicago professor named Alan Bloom, who published a book called The Closing of the American Mind, How Higher Education Has Failed Democracy and Impoverished the Souls of Today's Students. And it would seem to me that Bloom would say, you know, precisely when you treat the university the same way as you treat protests in the streets, all right, when you treat them as synonymous, you undermine in a significant way the mission of the university. How would you respond to that?
Well, I mean, in one sense, I agree that protest and speech on the streets are protected by the First Amendment, depending on the circumstances, time, place, and manner rules, and so on. But what's going on in university campuses today is different. If people were putting up tents on streets, it would not be protected speech. And so, again, what I think is interesting about the current moment is that the protesters have clearly effectively figured out how to engage in expressive activity that they know is incompatible with the ordinary rules and regulations of the institution, precisely to create this conflict where presidents don't want to have to tell them, shut up, you got to take down your tents and go away, but also don't want to allow them to stay there. And to the extent they allow them to stay there, they will just get more provocative and more loud. So it's an interesting game, I think, that's going on, a very strategic game that's going on here, where the protesters are quite intentionally being provocative in order to get attention.
So David Keating and Lynn Oberlander have a question. What are your views about the anti-masking laws?
I think that I was interested to hear Erwin's comment about that. As a general matter, we agree that anonymity is an important element of free speech, that people often don't want to be held accountable for their views, even though they want to express them. And they can therefore write things that are anonymous and distribute leaflets without putting the names on them, or write articles or put things on Facebook without identifying themselves. And for the most part, I think it's the case that we would regard that anonymity as an important element of enabling free speech. So in the mask context, I was surprised at Erwin's notion that masks should be impermissible. I do understand that people wearing masks makes it much harder to punish them if they're doing something that's wrong and that's inappropriate. But at the same time, so here's the question. If they're doing something that is truly punishable, then they shouldn't be wearing masks to get away with that. If they're doing something which is provocative and controversial and they don't want to be condemned for taking a particular point of view, then it's okay to wear a mask. And the question is, how do you draw that line? But I do think in the current circumstances, there are many instances certainly in which people are wearing masks, even though they know they're violating the rules or the regulations of the institution in order not to be punished, rather than not to be known to have taken a particular position. But it's complicated, because I do think that free speech does include the ability to and the right to be anonymous about one's positions, but not necessarily in a situation in which it makes it impossible to punish someone who is actually violating the law.
If somebody were to violate the law while wearing a mask, David Keating asks, might there be enhanced punishment for the wearing of a mask?
I don't know that the law does that, but I could imagine that to be true. If somebody robs a bank and wears a mask, I can imagine punishing them more severely for wearing a mask than not for wearing a mask. I don't know that the law ever does that, but it wouldn't strike me as crazy.
Seth, do you care to, we're still waiting for other questions? And
So-
Jeff, by the way, thank you so much for pitch hitting in the way you are. We really
Pleasure.
appreciate it.
Yeah, this is great. It's really great to have your perspective. Let's just give it another 60 seconds, see if anybody else has a question, and then if not, we can call it a wrap, because we're pretty close to time in any event. And
While
I take
we're-
it. Go ahead,
ahead.
Ron.
No, I'm fine. We're both
Got a lot of
two
questions. You go ahead.
Right. So, how serious do you think these campus disruptions are to the future of education and the future of free speech?
My guess is that they are relatively momentary, that whatever resolution occurs in the Middle East, and hopefully at some point there'll be some resolution of this, that these issues will go away. And the question then is, will this become a model for the future? And I can imagine it would. I mean, I think that these protests have been very successful at getting national attention for the position that these speakers wish to get. And if I were thinking about protesting something 5-10 years from now, the lesson I would take away from this is a way to be much more effective in terms of getting attention from my point of view. Now, the downside is you run the risk of being punished because you're violating otherwise neutral and appropriate rules. So that's always the downside. But I do think that the lesson one would take away from this, I think, is that this is an effective way of getting your views expressed and heard, not only locally, but nationally. And I think that's something that speakers would want to do.
So we have a question, and what are we to make of the Israel-Hamas war? I mean, in terms of it's a war, but it also has religious implications, all right, as we've seen from some of the protests on campus. How do we navigate that principle, that is the free speech principle, particularly when it comes to condemning countries in wartime, with the whole principle of anti-discrimination and anti-Semitism?
Well, I mean, I understand why from the river to the sea, or words like genocide or Zionism can be interpreted as anti-Semitism. And at the same time, I'm not eager to draw that inference, even though I'm Jewish. My view is that you can be very upset with people in a particular country in the way they're doing something, without necessarily thinking that everyone who shares the national origin of those people or the religion of those people is evil. So I would be inclined, unless it's explicit, not to treat those kinds of statements as anti-Semitic. Unless someone says Jews should all die, Jews suck. You know, that if they say that, that's anti-Semitic. But I'd be reluctant to draw the inference, even though I understand why people do, from saying Zionism is a nightmare to saying that means that you're anti-Semitic.
Seth?
So let me ask one other question that we have from Wendy. Imagine if you have a faculty member who speaks on, for example, trans issues. This is not a religion example, but we use this example. And then trans students allege that the faculty member is creating a hostile environment for trans students, right? And so on the one hand, you have a claim of harassment. On the other hand, you have something that's an expression of the viewpoint. And how do you resolve that?
Well, I mean, I think that faculty members have the freedom to say what they think is true and what they think is right, even if it is offensive to others. If you go back 50 or 75 years, there were faculty members who may have said that I think, you know, sexual orientation is not something that should be condemned, or that abortion should be legal. And at that time, many people would have said, that's horrible. How dare you say that? So I do think that faculty members, like others in a society, have the right to say what they believe and what they think, and it shouldn't be suppressed because it's offensive to other people. Now, again, people who are offended by it should respond. They should say, I think that's a terrible thing to say. I think you're wrong. But I don't think that the institution should be in the business of censoring in those circumstances.
Let me ask the final question on that, which is, you know, the examples that you just gave really illustrate why at its heart we have robust protection for speech on college and university campuses, which is that it's meant to be, you know, the freedom to engage with difficult ideas and then to engage in discourse with other members of the community, of both the academic community and the community at large. And it seems to me that one of the mismatches, if you will, between the current campus protests and that model is that your, people are, we'll say to students, well, look, we'll protect your right to chant slogans and sound bites in the quad. That's not really why we have free speech on campus. That's not the core of it. The core of it is to actually engage in nuance and reasoned discourse. And I guess my question for you is, how do you get from point A to point B on that, especially when, as you point out, in some of these instances, the point of the protest isn't actually to engage in that process, but to sort of deliberately violate neutral policies for the purposes of calling attention to the cause that you're advocating for.
That's a restatement of the Alan Bloom question I was asking, so forgive me for interrupting.
I think one of the fundamental responsibilities of a college or university is to educate students about the importance and the value of having an open mind and being civil and listening to one another and recognizing that many of the things that they today believe to be true, their grandparents who went to the same institution would have thought to be absurd and offensive and ridiculous. And then I think it's important that universities take the time and effort to educate students and citizens, for that matter, about the importance of having an open mind and being civil at the same time. I think it's also the case, even though universities shouldn't punish incivility, that they should encourage civility. And I think that makes a difference. It works.
And what is the message to the faculty? If I'm a faculty member, how do I balance my right or my interest in sort of expressing my own viewpoint about a particular issue, whether it's the Israel-Hamas war or trans issues, and to use the most Wendy's recent example, and on the one hand, on the other hand, sort of setting the example of keeping an open mind, because it does seem like in some respects those things are running in opposite directions, which is I get to have my viewpoint, but I also have a sense of stewardship of the educational mission of the institution.
Well, again, I think it's perfectly fine for faculty members both to state their own points of view and to argue that not that the university should adopt their points of view, but that the nation should, and that students should listen to them and buy into what they think is right, but also be open to criticism from the other side. And that's an ideal. I understand that's not necessarily the reality at almost any universities, but it's something that I think universities should aspire to. And one of the things that we should know at the moment is that we don't want to go back to the world of you punish anyone who's communist, for example, or you punish anyone who's pro-civil rights if it's a Southern university. And basically, you want to encourage people to have an open mind and to listen and to think and to reason. And I think you can do that. Apple has done a very good job over its history of creating that environment. Not perfect, certainly, but for the most part, that's who we are. And that's a central part of how we define ourselves. And that's why people come here, both as faculty members and students.
Jeff, you sound so much like your former boss, Justice William Brennan, and maybe that could be a future salon. What would William Brennan think? On that note, let me thank everybody, first and foremost, Erwin Chemerinsky, for taking the time to be with us. Seth, you did, I think, a remarkable job with the interview. A big thank you. Jeff, thank you so much again for participating and for your help. If you like this First Amendment Salon, we have some incredible ones coming, so stay with us. And again, thank you to everyone. And with that, we say good night.
Sure. Thank you, guys.